Welcome to the National Real Estate Network video training program. This video is part of a series designed to help beginning and experienced real estate investors with the different aspects of purchasing and investing in properties. Be sure to click become a member at 27monthlymeetup.com.
The other risk for so the benefit to this, though, is, like I said, is that you get you could get the probated estate open, you can sign the purchase agreement, and you can close on that, and you can build into the cost. Say maybe you wanted to renovate something, we'll build into the cost my fees, the probate fees, and the attorney fees, along with the renovations you want to make and things like that. And then you could just recoup your costs that way. So there is an added benefit. It's still a risk. Although since I've been doing this, and I've done it probably half a dozen times in the last year, I haven't had anyone that's backed out of the deal. Most people seem to be honorable, but it is a risk because you don't have any binding contract. And of course, everyone knows statute of fraud applies to real estate transactions. So if you don't have it in writing, it's not an agreement. There's no promissory estoppel or anything like that you can do on this. Try to say, well, we had a verbal agreement, or they made promises, and they're not upholding their end of the bargain. It's statute of fraud applies. So there is a risk there. But overall, I see a lot of real estate investors try to do this. In fact, I had one that tried to do it without going through an attorney. He was going to cover the cost for the family member to open up the estate and have the family member be the PR on their own, and things like that. And it turned into a giant disaster. They were essentially 3 months behind the real estate investor's schedule, and then they ended up coming to me to resolve it. So people try to do it on their own, and if you can work your way through the probate proceedings, it's fine. But I think when you're doing that, you're borderline practicing law without a license, because what you're doing as a real estate investor is advising the family member, the personal representative, how to open it, giving them money to open it, trying to guide them through, and you're not an attorney. So I think you run the risk of practicing without a license at that point. And I know you real estate investors like to draft your own contracts, so you guys like to do that anyways. But you run the risk once you're going into court. So I would always recommend getting an attorney if you're going to go that route. So that's what I had prepared. I don't know if anyone has any questions.
Dave, this is Mark Mappin. I've done what you just described there in the past. Is it legal to write an offer to purchase subject to the house going through probate?
Yes, it is, but understand that the other party, right? When we're talking, this is contract law. So the other party has to have standing, essentially, for lack of a better term, in order to enter into the contract. You could sign a contract with me and say, hey, once I own the Brooklyn Bridge, I'll sell it to you. Chances of me ever owning it are slim to none. So you can, and it's legal, but in the end, I think you're going to have a really hard time enforcing it.
Right.
It's really sort of an honor system. You really got to trust the people you're working with.
Right. So it's just a calculated risk.
Trust the attorney, that you're working with as well, I say.
Right. So
with an attorney that and you've used in the past, I would think that you'd be pretty good. If you're working with someone that you don't know, or someone that the personal representative or the family member has retained or contacted, then I would be a little bit leery. I would maybe bet a little more, or maybe get your own attorney too. There could be two attorneys.
Got it. So if a lot of the guys that are on the call are investors, so how would they go about researching probated estates, or even maybe probated estates that or property where somebody's died that wasn't probated? Is you any tips on how we could research that especially if we can get a deal put together and bring it to you.
Yeah, yeah.
How we
So, well,
can
so
be nice with you.
what's that?
I said how we can make nice.
Yeah. So the probated estates are fairly easy. You can go to legalnews.com, I believe is what it is. And you can go by county. So there's Monroe County Legal News, Oakland County Legal News, there's Detroit Legal News, and then there's Outer Wayne Legal News. You can go through all that. Go to their website, subscribe. You can select all the regions you want, and they will give you a daily list of all the new probated estates that are open. As far as tracking down leads to non-probated property, the problem there is that there's no published list of recent deceased, people that have died. There's no database that I know of, anyways, that you can get access to, say, death certificates. I think what you're doing, the way to get those ahead of time is to do the mass mailings. If you're really focused on something like that, maybe targeting homes that have been owned for, say, 30, 40 years, and sending out mailings into those communities, older communities, things like that, where the chances of a family member getting a hold of the mail from someone who's recently deceased, things like that. I just don't know of a database.
Guys, what you can do is if you want to ask a question, there's a place where you can raise your hand, and then Maureen can unmute you and you can ask your question to Dave. Dave, in the past, I also had probated estates where the person's net worth was really low and the attorney was able to probate it at a way faster rate than a normal estate. Can you talk about that just for a second?
Yeah, so basically it's a probate by affidavit, where it's not what I want to say. You don't have to open up the probate. You don't have to go before the court and get appointments and things like that. It's basically a probate with affidavit, and I don't know the statutory limit on that off the top of my head. But there is a way to do it, was essentially signing over the affidavit and doing it. But you're looking at a really low value.
Exactly. That's what I was chasing.
You're looking at a really low value home.
Well,
because anyone with real estate, even, most of the rundown things down there are going to put you over that market. We had one where the home was sold. I want to say it was like 20,000. And there was still, after the mortgage, because there was some sort of weird residual mortgage thing, I think the estate was getting 12 grand, and that even we had to open. So, but it doesn't cost a lot to open it. And the other thing too is, a lot of people talk about the inventory fees. So depending on the amount of the actual assets, you take in, say, whatever, bank accounts, cars, vehicles, whatever holdings this person had that didn't transfer automatically to someone else, you add that up, and the court calculates out a fee. When we did this one at net worth of 12,000, I think the fee was like $75. With my fees, my time plus the filing fee, I think the total cost was like $800. It's not a lot.
Got it.
Something like that. So the advantage to doing it that way versus the other way, you're saving yourself really maybe $300. And that's if you can fall under that threshold.
A lot of times when the property has really extreme low values, like you were talking about, the attorneys just elect to abate the property. In other words, walk away from it and let it go back for taxes. Is there any way to be able to research that to find out which properties are being abated?
So the county will have a list of properties that are in tax foreclosure. The tax foreclosure at the county level will get posted only a year after the taxes have been due. So you're sort of behind the ball a little bit on that. I don't do a lot of real estate investing myself. There might be something at the local levels, at the city levels, who actually imposed the taxes originally. that whether or not taxes are due. I mean, you can look up individual properties, but as far as researching it, just looking for properties that are in tax foreclosure, you can go to the county level for that.
So if like one of those junk properties, you abated it with all due respect because there's no value there, and along came an investor at a later date, can the estate be reopened to be able to pick that property up?
Yeah. If you want to purchase that and it hasn't gone into tax foreclosure, meaning the county is not selling it on a tax foreclosure, you want to purchase that, you can open up the estate. You can get so find the owner, the registered owner, get a copy of his death certificate, and then go ahead and open the estate. Now you have a duty now to track down all interested persons. When you open the estate, you also have to post it in the newspaper that an estate's been opened. And that's why we check the legal news. So you have to post it there. And then, you'd be able to do that. But you have to, the court's going to make you jump through hoops and make sure you contact any known living relatives.
So, like, could you give me a rough idea what the costs could be associated with something like that? A range, maybe?
So, I mean, again, the procedures are fairly same no matter what you do. And unless and until somebody comes in that's an interested person and says, no, I object, I want the house, or puts up a fight, the costs are about the same. You're going to be under, worst case scenario, you're going to be under $1,500 for my fees plus court fees.
Right.
It's not, the paperwork is the same. The publication fee is the same. The inventory fee, depending on the value of the home, might go up or down, but you're going to look at $1,500. You should be, you should be able to do that. If you're being charged more for that to open up a probate and to process it on really just the real estate matter like this, like we're talking, low value real estate, people walk away from them, something's not right. Absent, of course, a long lost family member coming in and throwing hay into the proceedings.
Got it. So, Maureen, do we have people with their hands up? There's no dumb question by anybody.
Yeah, ask away.
I don't see anybody raising their hand. Come on, folks, ask away.
Maybe.
Someone said on the chat too, I need information for buying through probate court and mortgage foreclosures. I think I get the gist of probate now. So was there any follow-up to that? You think you get the gist of the probate now. You need more information on buying through probate court and mortgage foreclosures.
I've got some people that generate probate lists, so you could just email me afterwards. I can give you that information.
Okay,
that was
that was me.
Okay.
Yeah, I did it.
Did
you have any
answer your
follow-up
question?
questions on that, or?
I actually asked the question or made the statement before you got on, and you answered it as soon as you.
Oh, all right. Very good.
Already answered.
So yeah, again, sorry for being late. How many are with us today? How many do we have in here?
We have 20. We have 18 people, 18 guests on here.
Okay.
So come on, folks. Do you have any questions for David?
Yeah, Dave, what we're going to do on this is
How often do you get to ask an attorney without,
Yeah, I'm not charging you here.
Yeah,
That's right.
yeah, ask all your hypothetical questions right now. That's what I'm doing. So we're going to record this and then ship it out. So from a real estate perspective, since it's going to be all going to real estate investors, so would you handle landlord-tenant, or do you have somebody in your firm that would, or?
Yes, we do. Hoyle is my associate who does most of our landlord-tenant stuff. Sometimes on trickier cases where the facts are a little weirder, I'll handle those. I'll take the lead on those. But we do a lot of probate, we do a lot of landlord-tenant. And we're in a weird area with landlord-tenant now, with this whole COVID thing. So, the biggest thing that we are stressing is that, a lot of our clients on the landlord side are worried that their tenants are going to feel like they don't have to pay rent because they can't be evicted. So we've been sending out a few letters Just reminding them that no, the governor didn't cancel your contract and you can't live here for free. You still need to pay your rent. And then for a lot of our tenant clients too, because we do represent both landlords and tenants, we're not biased. So long as we don't have a conflict, you know, they have the same questions. Do I have to pay rent? And of course the answer is yes, you have to pay rent. And if they have no income, you know, then that's something that, you know, they'll have to deal with. But you know, they're still obligated to pay rent. So we do a lot of that. If you have a real estate investment that's backed by, say, essentially any sort of federal backed mortgage, right now you are not allowed to evict until July 25th or somewhere around there. You are not allowed to evict, even though the courts are starting to open up again. The Supreme Court has put a lot of pressure on district courts and circuit courts to open back up and to conduct hearings. In fact, I had one earlier today. I have one tomorrow. I had one on Friday at the district court level, as well as the circuit court level. They're back up and running. We're doing it via Zoom. I haven't had any landlord-tenant proceeding via Zoom. I don't know if those are back up and running yet. I don't know if the Supreme Court has released the courts to do that yet. I think the deadline is maybe in June, June 15th, popped in my head for some reason. But those will be back up and running. But if you have a federally backed loan on that property, you will not be able to evict anyone until July 25th, I believe. So you still have to wait. But again, that doesn't say that doesn't mean that they don't have to pay. The tenants still have to pay. So remind them of that.
Okay, David, now, so I'm going to ask a couple of questions of you. So speaking of that, now, is that the actual action of eviction, or is that just the filing for the 30-day notice to quit or 7-day notice to quit? What are you speaking specifically of for July?
So my understanding is that pursuant to the CARES Act, which is a federal act, and they do have authority here because it's a federally backed loan. But under the CARES Act, you are not allowed to initiate a summary proceedings for eviction. Now, in my reading of that, it does not pertain to notices to quit, 30-day notices to quit. It only pertains to actual filing of the summary proceedings.
Okay.
So you can give your notices to quit out by August 1st, and then proceed with the eviction August 1st.
Okay, because I know that some people, I saw this where some people were asking in some of the investment groups on Facebook, you know, that very specific question, because they were thinking that they wouldn't be able to file their notices, okay, and that they would have to wait, you know, an additional 30 days or whatever. And so that's why I was just looking for a little clarification on that.
Yeah, and so my reasoning about that would be that a notice to quit is not a court action. It's not a court document. It's not anything. It amounts to a prerequisite to a court action, the same way that in order for you to file for a breach of contract, you must first have a contract. So it's not a court action, the notice to quit. And therefore, I don't think it falls under this requirement that you cannot evict until July 25th.
Okay, so now my second question, which is, since you kind of brought up the landlord-tenant issue, would be about real estate. And what are your thoughts on filing LLCs, purchasing properties in those LLCs versus purchasing them in a personal name?
Never.
And should you open one up for each individual property, or can you put them under one LLC? And if so, is that something that you offer services to do?
Okay, so a lot of questions there. I do offer these services, and if there's something that you ask and I don't offer services to, I will tell you. But yes, we do offer those types of services: LLC formation, corporation formation. So for the purposes of this discussion, I'm going to treat an LLC the same as a corporation. The difference really being tax implications. So if your income is to the point where you really want to start dividing up your tax filing, that's up to you and your financial planners. But you want to own each, this is my recommendation. and then I'll tell you why. You want to own each of your properties in a single individual LLC or corporation that owns only that one property. Then you want to own a corporation or an LLC that owns all of those little LLCs, sort of an umbrella. So think of it like a pyramid scheme. That's what you want. And I'll tell you why, because when, if you were to own everything in your own name, and the judgment against you because of some sort of liability that happened on one property, because you own it in your own name, all of your income, I'm getting a weird echo, all your income is garnished to you under that judgment, including every rent from every single other property. So although you can own all of your properties in one LLC and therefore insulate yourself from the liability or the collections, all the income from all those other properties, if they're owned in one LLC, can also be garnished. So in order to protect yourself and completely isolate each individual property, you want to own each piece of real estate in an individual LLC with a, say, a parent company over top of them that owns each of the little ones, and then you can be 100% owner of that parent company. The dollar will always travel up to you. The tax obligations will always travel up to you, but the liability and the garnishments, the ability to garnish and collect on any sort of liability, will stop at that one LLC. Does that make sense? I hope.
Absolutely, yes. So basically what you'd be doing is you'd be setting up almost like a holdings company. And then below that, you would have the individual property LLC.
Yep, and you, in order to, so one of the, I don't know if I'm getting some weird feedback, but one of the other concerns too is piercing the corporate veil, which means that, did you guys hear me okay?
Yes.
Okay, all right, just weird on my end. So piercing the corporate veil is, in the traditional sense, is when an individual owns a company, but treats it as, say, his own personal checking account. And if you get, say, a lawsuit against that company and that company is liable, you can also pierce the corporate veil by say that this owner is treating this as basically a sole proprietorship, not really a separate legal entity, and therefore we can get at him directly. The same thing applies when you have these multiple LLCs with a holding company. Because that, you want a bank account for each one of these specific LLCs. You want to keep transfers, you want a bank account for your holding company, and you want your own personal bank account separate from all of those. It sounds like a lot, but in the end, if you get a major sort of incident going on one of your properties, it could wipe everything out. So you want to make sure that you insulate yourself. So you want separate bank accounts. You want to treat them as separate legal entities. LLC 1 owes its dues to the parent company, so it transfers every month whatever it needs to do, and then the parent company will pay you, things like that. So you want to keep them as their own isolated entities with bank accounts and everything you do. Keep separate accounting records and all of that.
Yeah, no commingling of funds. And
Yes.
and then the other thing is for tax purposes, that's the easiest way to keep track of everything, because all of the expenditures and everything then will be allocated directly towards those properties. And so, you know, when you go to sell, it's real easy to figure out, you know, profitability versus, you know, whatever, losses.
Yeah, and if you need, if the parent company needs to loan money to one of the LLCs in order for them to invest in something, it should be a loan, not an investment necessarily. And then same thing from you individually down to the holding company. You know, you could denote a loan down to the holding company that distributes to the other LLCs. You just have to treat them as separate legal entities.
And this is why, folks, you should always consult with outside entities, such as a CPA, such as, you know, an attorney, etc., when you're setting up and establishing these businesses. It's real easy to do through the state, you know, personally. However, I always recommend that at least the first initial thing that you do, you seek outside, you know, consultation. So I see we have a hand here. Stephen?
Yes, thank you. I've got a question. You might have just answered this, David, so I apologize. But I guess what is the point in the one LLC that holds all the ownership to all the underlying LLCs? How does that add additional protection?
So the additional protection would be that if you own, if you personally own all the individual LLCs, but you're not running them as separate legal entities, or for some reason they're able to make an argument that you're not running them as separate legal entities, and for somehow, some way, they're able to go up a step and say that this is not being treated as a separate legal entity. Therefore, we're going to pierce the corporate veil and go up to the owner. You just added an extra layer of protection for yourself, because they can garnish, file liens on your home. They can garnish your personal income separate from this and things like that. So it's not absolutely necessary. You can own each individual LLC yourself, but it's an added layer of protection.
Okay, I think, yeah, I guess you had already answered it. Yeah, that's where I kind of just, yeah, I'll have to think about that.
And you can structure it in a way, again, they're all LLCs, so the tax flows straight up to you. And you only have to file the one tax return. You do have to do a bunch of other stuff, but if you have a corporation, and say you have multiple partners going into a corporation, then you can structure everything a little differently. But if it's just you, I still recommend the parent company own it all, just as a extra insulation.
Okay, and then I guess I have another question as far as the whole probate with the real estate. If I were to find someone that passed away and they had a house, and let's say, I guess two scenarios. One scenario, they didn't have a personal representative, and one scenario, they did. So if they didn't have a personal representative, then I would use an attorney to open the probate case.
Well, so let me explain the personal representatives a little more. If someone dies with a will, they will usually nominate an individual to be a personal representative. And then if that person's unavailable, they usually have a secondary personal representative. Most of the time, people pick the oldest child or maybe the most financially responsible child as their first selection, after their spouse, of course, and then go down the list. If someone dies without a will, then there is no designated personal representative. Now, the priorities in order go the spouse and then the children. If someone dies without a will, their property will go first to their spouse. If they have no spouse, then to their children. If they have no children, then to their grandchildren. If they have no grandchildren, then to their siblings, and then down to their nieces and nephews. That's sort of the order of devisees without, it's called the intestate devisees without a will. And the same priority goes that way for personal representatives, unless there's some compelling reason not to. Say the spouse is a gambling addict and drug addict and can't be responsible, then maybe one of the children can step in. So, but that would be the priority for the personal representatives. If nobody's willing to do it, then you could, as an interested person, you could, as a creditor, file in and appoint yourself as personal representative and proceed that way. But just because there's not a will and there's not a designation of personal representative doesn't mean that you yourself have to do it. You can get a hold of a family member, a spouse or a child, and say, hey, let's, if you want to sell me this, we can open it up and do it that way.
Okay, so, I guess in either scenario then is, so in majority of the cases, the major asset for that individual would be the real estate, and then it would be that person who opened up the probate to post to all the public and potential creditors. So, I mean, going down that road, the person who opens up the probate, like you mentioned, the